Yes, sir.
Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Put your hand down, please. Mr. Hathorn, you may have been listening on the previous pleading. Either way, it's 10:52. Is 11 o'clock ready? Hold on, Mr. Hathorn.
Yes, sir. That he's there. He's present.
Goodness.
Mr.
Mr. Hagee?
That's the attorney's name.
Oh, no. Austin Hagee.
Maybe Miss Salazar is appearing for him.
Huh?
Miss Salazar is might be appearing for him.
Okay, Jose Alejandro Bustamante.
Yes, Your Honor.
Good morning to you.
Good morning.
Is your attorney with you?
No, I don't see him on the thing.
Judge, I'm here to represent Mr.
Okay.
Bustamante on behalf of Mr. Austin Hagee. I'm sorry, I need to fix my name here.
Okay, what is your name?
William Salazar. And I did sign the plea documents.
Are they all state or all these documents in this case ready?
I sent them to the jail and I just need Mr. Bustamante's signature on them. That's the only thing we're missing.
Okay,
I sent
so
them
the answer is the papers are not ready?
That's correct, Your Honor.
Okay, and we'll just go ahead and proceed with.
Your Honor, while you're taking the other plea, you can ask Mr. Bustamante to ask the deputy to look for that paperwork for him.
Okay.
Mr. Bustamante.
Yes, sir.
All
Yes,
right.
Your Honor.
You need to get the deputies there, make sure you've got all the paperwork that you're supposed to review.
Yeah, I
sign.
already called them right now to get a.
Okay, you heard my boss talk about that?
Yes.
All right,
I need documents that
I'm
I'm
gonna need
supposed to be
it.
signing.
go ahead and mute yourself, Mr. Bustamante, for right now. We're gonna take care of another matter. Mr. Hathorn,
Yes, Your Honor.
you've been sworn in, you understand you're under oath, right?
Yes, sir, Your Honor.
All right. Before we proceed, I want to discuss with you several different rights and protections, constitutional protections that you have. They are essential, and I need to make sure that they're on the record. Now, you and I are going to discuss these verbally. They're going to be recorded officially by my court reporter, Ms. Kayleen Duvera. In addition, these rights and protections, we're going to repeat them several times in writing in the documents that you have reviewed. So, first of all, you have the right to remain silent. That means you don't have to make a statement, answer questions, or submit paperwork that has your signature, especially papers wherein you confess or admit to wrongdoing. That's the right to remain silent. You understand you have that right?
Yes, Your Honor.
You have the right to a jury trial. That means that you and your attorney and the state's attorneys would select 6 people from a random pool of jurors. And those 6 people would look at and hear the testimony and documents and materials that would be offered as evidence in your case. They would decide, those 6 people would then decide whether you're guilty or not guilty. That's the right to a jury trial. Do you understand that?
Yes, Your Honor.
You also have the right to cross-examine or confront witnesses. That's a way of saying you have the right to confront or face your accusers. Anyone that would testify in your trial, you'd have the right to question them, cross-examine them, or challenge them. That's called the right to confront witnesses. You understand you have that right?
Yes, Your Honor.
You have the right to an appeal. That, generally speaking, is you have the right, you yourself or your attorney by himself, or the 2 of you together, following the rules, you could demand that a higher court review the official record in this case, all the evidence and the results of this hearing for whatever challenge you wanted to make. Obviously be a legal challenge, and those rights or the right to appeal, you'd have to follow the rules, the forms, and the time limits. You understand you have the right to appeal.
Yes, Your Honor.
Then you have a right called the right to a open and public hearing in the public courtroom. Because of the COVID pandemic, we're not doing it. We're doing it by video conference, but it requires your agreement and consent. Do you understand you have the right to demand the hearing in public courtroom?
Yes, Your Honor.
All right, those rights that I have just reviewed with you, if you persist in a plea, entering a plea, you give those rights up. Do you understand that?
Yes, Your Honor.
All right. Now we're going to show you some documents. At the top of each document, with one exception, you're going to find this basic identifying information. It has your case number, which is 635977. You have, what? Nothing. You have, it says the state of Texas versus Mark
Burdette?
Burdette Hathorn
Yes, yes, sir.
in County Court of Law number 5, Bexar County, Texas.
Yes, Your
Now,
Honor.
this particular document, this one belongs to the state. This is where they agreed to a video conference because they have that same right that you have to have this or to demand that this hearing be made in the open public courtroom. They have signed, Ms. Caitlin C. Morgan has signed on behalf of the state that they agreed to the video conference. By the way, the video conference is being streamed on YouTube, so all the public that has a computer can tune in and watch and hear this proceeding. Do you understand that?
Yes, Your Honor.
The document in front of you now, again, the identifying information. This has, the title is Discovery Acknowledgement. It's very prominent, all capitals in bold print. There is a specific law, and it's recited there on the very first line. It requires the state of Texas, the prosecutors, to share with you, to acknowledge all the data, receipts, books, videos, whatever is involved in your case. And this is signed by the state of Texas attorney and your attorney. They're saying publicly on the record that that law has been obeyed. You understand that?
Yes, Your Honor.
I'll be approving all these documents. Now, the next document is yours. This is the one wherein you agree to the video conference. Do you see that? Did you review that and understand it?
Yes, Your Honor.
All right, any questions?
No, sir.
All right. The next document is it's called Defendant's Waiver of Constitutional Rights and Court's Admonition. Mr. Piker, did you and your client review this document carefully?
Yes, we did.
All right. Mr. Hathorn, did you notice that it says in there that you are entering a plea of nolo contendere to terroristic threat?
No contest.
Right. Do you see that on those papers there? It's the third sentence starting at after the identifying
Yes, right.
information is typed.
Yes, Your Honor.
All right. Now, after that, there's 15 numbered parts or divisions of this document. The number one part there, it talks about the punishments for different crimes. There's a stack of little boxes, and next to each one is a particular type of punishment for either a level of offense or a particular type of offense. There's only one that's check marked. What does it say?
Class B, $2,000 fine and up to 180 days jail time.
All right. To be a little more accurate, it's a fine from $0 to
Oh, yes, sir. I'm sorry. Yes,
That's
0
all right.
to,
Now, did you review this entire document with your attorney?
yes, I did, Your Honor.
Did you, where were you born?
Houston, Texas.
All right. The papers will obviously reflect that you are a U.S. citizen. One thing I need you to be sure of is that I need you to understand that the deal that you've made, called a plea bargain, as a judge, I am required by law to approve it or disapprove it. I have to say yes or no, one or the other. I can also give you any punishment in the range of punishment that is the Class B that you just read, even if I give you a punishment that's greater than what you agreed to. Now, be aware, if I say, no, I'm not accepting this deal, or if I say, I'm going to give you a heavier punishment, in either case, the law would allow you to start all over again. You understand that?
Yes, Your Honor.
All right. And you reviewed this with your, Mr. Piker, you reviewed this with Mr. Hathorn?
Yes, I did.
Are you satisfied that you understood this document?
Yes, he did.
All right. And Mr. Hathorn, you signed that. I saw your signature.
Yes, sir,
Did
Your
you
Honor.
sign this?
Yes, Your Honor.
All right. This next document with the identifying information, this one is titled Trial Court Certification of Defendant's Right of Appeal. There's a stack of vertical stack of boxes. Each one says something different about a right of appeal. The fifth box will be marked for the record. It says this is a plea bargain case and the defendant has no right of appeal. Did you understand that?
Yes, Your Honor.
All right. We'll proceed now. This next document is called Application for Deferred Adjudication. Did you hear me explain this to the previous party?
Yes, Your Honor.
All right. I will make sure that you understand it.
Yes, sir.
Deferred adjudication. First of all, you're making an application here. You're swearing to the information that you're providing. Some in particular is very important. A deferred adjudication is a written legal binding agreement between you and this court. The beneficial thing that Mr. Piker has gotten for you is that, in particular, is that if you live up to 100% of the conditions of supervision, you will not be convicted of this charge. The case will be dismissed, and under Texas law, you do not have a conviction of it. That requires you to live up to 100% of the conditions. Those will be read to you. You will sign them. You will have a copy in your hands. The particularly important part is that even though you're going to plead nolo contendere, no contest, which is a plea that the court takes as a guilty plea, and is a plea that is sufficient to convict you on, I will not convict you. I will postpone that. I will defer that. And if you live up to 100% of the conditions, then the case gets closed, dismissed, and you are not convicted. Is that clear?
Yes, sir, Your Honor.
Now, obviously with that, there is an opposite. If you fail or refuse to live up to the 100% of the conditions, then at that point, the state can ask me to give you official notice, bring you in for a hearing, and in fact, enter, depending on the evidence, but I could at that point enter a finding of guilt, a final conviction, which would stay with you the rest of your life. Then I would be looking at 100% of the punishment range. Is that clear?
Yes, Your Honor.
All right. Now we're going to look at the actual plea agreement. Oh, I'm sorry. First thing is a personal data sheet. Did you and Mr. Piker fill this out?
Yes, sir, Your Honor.
All right. Now, who's your employer?
I'm self-employed.
What do you do, sir?
I own a construction company, general contractor.
All right. So what is your total income, either monthly or yearly?
It's an LLC corporation, so after I pay my guys and everything before taxes, it's about $850 a week.
Okay. And you're married or single?
I'm single at this time, sir, Your Honor.
Do you have any children that are under 18?
No, sir.
Okay. You have a vehicle, okay. Chevy 2500 already. Okay. Did you put only true and accurate information in there?
Yes, sir, Your Honor.
All right. Here is the plea agreement. This is the
Yes, sir.
deal that you have made, that the state has agreed with you on and are recommending. The first two boxes will be marked officially. The first one is that you've been fully informed and reminded of the right to remain silent. The second one will show the world that you are a U.S. citizen in regard to this matter. Then you have another section. It's called Dependents Acknowledgements. There are 5 little vertical boxes. Those boxes, each one of them has a different statement concerning your constitutional rights and protections. You did review this with your attorney, and very clearly, did you understand this section and what it says?
Yes, Your Honor.
All right. Scroll, please. All right, the section that you're looking at right now is where it says what is the specific violation that you are being prosecuted on. The last box on the right says other, and the title is terroristic threat. To that, somebody marked it not guilty. That is not correct. I am asking you officially, and it will be reflected in the documents, what is your plea to the charge of terroristic threat?
No contest.
That is correct. It is no contest. It will be reflected on the paperwork. You're seeing one that says not guilty. That is not an acceptable plea. You have corrected it. It is, in fact, no contest. Now, I order you to appear in the offices of County Court of Law number 5, in the hallway behind courtroom number 5, at the Justice Center. You are to appear within 7 days and have your thumbprint placed on the documents as required by law. I find that there is sufficient evidence to find you guilty, including your own plea of nolo contendere, but I do not make a finding of guilt. Instead, I am granting you 6 months deferred adjudication. You are
Thank you, Your
fined $400. You're fined $400. This document says you're being 400 is probated. I do not accept that. I'll talk about that to you shortly. You are ordered to attend, as part of your punishment, the APSE course. That is a anger management course. Is that understood?
Yes, sir, Your Honor.
All right. Now, scroll, please. Can you come back on that? Was there something else next to the APSE? Yes, okay. You will have no contact order. There's an order that you cannot have any contact with Pedro Rodriguez. Is that understood?
Yes, Your Honor.
Okay. And scroll, please. Your supervisory fee will be $38 a month. Now, let me address the fine. That fine will be $600. I will not probate any of that fine. You understand?
Yes, Your Honor.
Now, because I am increasing the punishment, I told you earlier that if I give you a punishment that's greater than what you've agreed to, you'd have the right to start all over again if you choose. You may want to confer with your attorney, or you may be ready to accept that change at this time. But it is, I inform you, it is a right that you have. Is that clear?
Judge, he does understand that. On that issue, I'd like to address the court briefly, if you don't mind.
I don't mind at all. Go ahead.
Okay. He is self-employed. He's trying to come back from being at La Hacienda Treatment Center. After this thing happened, he had hurt his back in the past, and he had a problem with the oxycodone. And so he was in rehab in Houston at La Hacienda for about a month or so. He recently got out after let's see, when did you get out? Early May?
May the 19th.
May the 19th. During that time, the house he lived in was a house that belonged to the family. When he was in rehab, the family sold the house, put all of his stuff in storage. So when he got out of rehab, he has no house to go back to. He's living at a suites situation, and all of his furniture is in storage. So he's starting basically from scratch to try to put up fences and things of that nature to get started again. So I'd ask you to consider maybe somewhere with that fine again, because it's enough of a burden to be self-employed, but then to start over again and come out of rehab with no house and no furniture, it's just adding to the angst of getting back on his feet. So I wanted you to know that on his behalf.
Mr. Hathorn,
Yes, Your Honor.
you heard the information that Mr. Piker shared with the court.
Yes, sir, Your Honor.
Are you telling me under oath that what Mr. Piker has told me is in fact true and correct?
100%, Your Honor.
All right. Then I will modify my fine. I will in fact make it $250.
Thank you, Your Honor.
I will not probate any of that, but that is a significant change from what I had already done.
Thank you, Your Honor.
Now, let me say this to you.
Yes, sir.
You're starting over
Yes, sir.
clean. The basis of my initial fine was that you told me you were making $850 a week clear, which is about
was prior.
approximately $3,500 a month clear.
That was prior to me going in.
Okay, well, that's why I had done the originally why I did the 600 and no forgiveness.
Yes, sir, Your Honor.
Do not fail us because you don't ask questions, or if you have problems, tell the probation officers about them. Don't just
Yes, Your
try
Honor.
to tough it out and figure there's nothing you can do about it. Probation will try and help you. They will try and not only guide you, but they can do things for you, including at the very least approaching the court for modifications or changes. I'm not above that. I can do that. So, hang in there, do your best. Where you have problems, say so. Okay?
Yes, Your Honor.
We're here not just to punish you, but to try and help you. So with that, do you have any further questions?
Just to say to the court, I apologize and thank you very much.
All right, good luck to you, sir.
And Judge, you may want to note that I had him take the anger management class as we were leading up to this plea. So he will be providing probation a certificate that shows that he has successfully completed the class.
When he provides the certification to the probation office, the court will take note and give him credit for that.
Thank you.
All right.
And also, the DA and I did talk, and they agreed that once Mr. Hathorn has been able to do all this, that if we applied and it was appropriate, that they would not object to early termination.
That is not a problem. The court will consider it at the appropriate time.
Thank you.
Thank you, Your Honor.
You're welcome. Okay, y'all are